Well, welcome everyone. We will go ahead and get started. Before we get officially into our program, I want to thank the Research Triangle Foundation. The Research Triangle Park headquarters, which is the building that we're in, is a site of occasional meetings that we host at the North Carolina Technology Association, and many of you have been able to come to some of those and participate in some of those. And we're really grateful to, first of all, have the foundation as an active member of the association and a great partner on events like this and allowing us to host here. So I'd like to introduce you to Bob Jolis. Bob and I have known each other many, many years and still like each other pretty well. He's a good friend, but also a great leader. He's doing some great things here for the future of the park that many of you have read about. So I'd like to ask him to take a few moments to welcome us, say a word about that, and then we'll get underway.
Great, thank you. Well, thank you, and let me begin by welcoming all of you to your Research Triangle Park. This park belongs to you and the other people in North Carolina, and those of us who have the privilege of working here at the foundation, our staff and our board, are enormously honored and proud of the opportunity we have to work on your behalf as stewards in the development of Research Triangle Park. We're obviously pleased that you chose to be here today. You're always invited to use our facilities. We're very pleased that to bring together such a distinguished group and a terrific panel to share ideas and to engage with each other. And if you think about it, that's really what the Research Triangle Park has been about for 50 years. How do we come together? How do we bring together a variety of interests from government and industry and our universities to work together and to collaborate? It's the thing that, frankly, we invented here in North Carolina. Everyone around the world has come here over the last 50 years to figure out how we do it. And while I don't think anyone does it as well as we do, there are a lot of places around the world that are getting pretty close. The competition is getting greater. And I'm pleased to say that with the support of our universities and the support of many of you here in this room and from industry, we are in the process of actively working to ensure that our park keeps its great global brand and its great global reputation, and that we continue to do what our mission statement says we are to do for Research Triangle Park. It says we're to do three things. We are to support education, we are to create meaningful work, create jobs, and we're to help lift up all the people of the state of North Carolina. And what a wonderful mission statement that is. It's a great feeling every day to get up and work on something as purposeful and as meaningful as that. And today we're doing that by focusing on three things: redevelopment, reconnecting, and reimagining. On the redevelopment side, I hope all of you are paying attention to the fact that we are, for the first time in the park's history, and I know Richard Stevens is here, and Richard was critical in getting the legislation passed that will allow us to bring residential and retail and amenities and services into the park. I say this many times for more effect than anything else, but we're 7,000 acres. We're half the size of the island of Manhattan, and you cannot buy a Starbucks coffee anywhere in Research Triangle Park. Now, we're finishing our plan that will bring coffee shops and sandwich shops and retail and residential into the park for the first time. We're very, very excited about that. But we're going to do it in a way that brings, that is inspiring, authentic to North Carolina, that's accessible and affordable to new technology companies, which I know you all are concerned about. Reconnecting is all about the kinds of conversations you're having here today. What can we do to facilitate that, to encourage that more often? How do we make sure that we are meeting that obligation by providing environments and formats in which people can share ideas and reconnect? And reimagining is something that I need all of you to be thinking about. If I left you with a charge today other than the one Brooks and this committee is going to give you, is this. What is the big thing that we can do together that's as significant and as meaningful for North Carolina as the big idea 50 years ago to create Research Triangle Park? Because think about that. We were at the bottom of the pack 50 years ago, 48th, 49th in the 50 states, and we made a big decision. We made a decision to create something as big as RTP, and it was risky. And there were a lot of doubters. And it took all of us working together to get here today. And so everything we have going for us is because of the risk takers and the visionaries 50 years ago. Well, we owe it to them, we owe it to ourselves, and we owe it to our kids to make sure that we continue to push on those big ideas. North Carolina is a state with a great destiny in this world. I believe that. And we have great responsibilities and obligations. And so I want all of us to think about, to imagine, what does that next 50 years look like for North Carolina, and how do we make sure we get there? So again, welcome. This is your Research Triangle Park. We're moving forward, and we look forward to you joining us. So thank you, and have a great meeting.
Thanks, Bob. Thanks to your team for helping us be here today. So as I said at the beginning, I'm Brooks Rayford. I'm president of the North Carolina Technology Association, or NCTA as we call it. And that kicks off a series of acronyms I'm about to throw at you, so pay attention. It's not too hard to follow. But we are the statewide industry group for the tech sector, and those that really includes everyone, because everybody uses technology to drive efficiencies in operations as well as to engage their constituencies, their customers, their audiences, and so forth. This includes governments, institutions, organizations, and companies. And I think you'll find if you look at our membership array that it reflects that, many of you in this room as well. There are similar organizations to NCTA, as you might imagine, in most other states and in the Canadian provinces. And so for several years, for many years, we've had a loose federation of us. And for several years, those North American tech associations have partnered with CompTIA. CompTIA is the Computing Technology Industry Association, and they are really the way that we amplify our voice collectively around the country at a federal level, primarily on issues that have federal importance or are exclusive to the federal side of things. So we've been active with them for some time, and as part of that partnership, CompTIA has worked with associations like ours to launch TechVoice chapters. One more, there's a logo right up there, up here somewhere. And so it's under that brand of TechVoice that we hold occasional sessions like this that might be about topics and issues that have probably lean a little bit more toward federal issues, or at least have parallel importance at the federal level as they do in the state level. Our North Carolina TechVoice initiative is co-chaired. Both of those co-chairs are here. One is Melanie Chernoff, who is sitting right here. She'll be moderating today, so you'll hear more from her soon. She is the Government and Community Affairs Manager with Red Hat. And Ron Culler, who's also right up here, is CTO of Secure Designs out of the Triad. And so the two of them help us determine our programming in the course of the year that we offer under this banner. As we were contemplating this summer, or earlier I should say, about this summer and what kind of topic we might put forward at a session like this, we focused in on the issue of patent trolls. It's been a hot topic at both the federal level and within the states, and NCTA has been part of a recent coalition, some of whom are represented here today, to drive some legislative action in North Carolina around the issue of patent trolls. A bill was introduced by Representative Tom Murry, who's on our panel today. He represents the Morrisville area. In addition to his being an author of a bill that has now passed the House unanimously, you have a copy of that, hopefully, that you picked up on your way in. There also is that same language, essentially, within a larger Senate bill that tackles larger issues, and that bill has passed the Senate unanimously. So the version of the language you see in front of you has essentially passed both chambers. The question now is what happens next? Who will take up whose bill? What's the vehicle that will see this through? And hopefully we'll get some insights today on what may or may not happen and what the path looks like. At the national level, Senator Leahy, who chairs the U.S. Senate's Judiciary Committee, yanked a federal bill from consideration just a few weeks ago. And the reason given was that the stakeholders in that instance were not able to come together with consensus about how to move forward in a way that we've been able to achieve here. So that really turns the spotlight back to the states. About half or more of the states have acted or are in the process of acting. In addition, the National Association of Attorneys General, including our own Attorney General, who's here, have endorsed the federal initiative, but are increasingly using or looking for ways to use existing authority to act at the state level. So as you can see, we've got a terrific panel lined up. on a very important topic. They bring a blend of expertise and perspective on all of this that I think will cover most of the bases. We also are supported today, in addition to being hosted by the Research Triangle Park, we are sponsored by Adapt IP Ventures and Alston & Bird. You can see on our screen. We appreciate their support as well. Our format is to have Melanie begin with some introductions and then move into some insights from our guests, like what exactly is a patent troll and why does it matter? At least that initial question probably. And after that, we'll have an opportunity for questions and comments from you, and then we'll invite you to network a bit when we adjourn. So with that, please join me in welcoming Melanie and our panel to TechVoice.
Thank you, Brooks. And I want to take this opportunity to first thank Brooks and NCTA for putting this together. Brooks, as you know, is one of our more outstanding technology leaders in the state of North Carolina. We're very fortunate to have him, as I'm sure that you all know. And Ron Culler, as Brooks mentioned, co-chairs TechVoice with me, and so he's very instrumental in helping to put this panel together also. So thank you, Ron, for your help with that. We want to start today by introducing our very illustrious panel, and thank you all for being here with us today. We're just going to do a few introductions first, and then I'm going to give each panelist about 2 minutes just to give us an idea of, who they are and how is this issue important to their community or to their organization. And then I'll throw out a few targeted questions and give each person a chance to do a little bit of question answer. And then we're going to open it up to the audience because we really want to hear what your questions are and take advantage of the intellectual capital that we have in the room today and really delve into the issue of patent reform or patent troll abusive litigation, as it's sometimes called, and find out exactly what they have to say and perhaps answer your questions and what can we do to help influence this issue. So first, I want to thank our elected officials for being with us on the panel today. Attorney General Roy Cooper, as you all know, is in his 4th term with the state of North Carolina, and we are pleased to have him. He's been a great champion, particularly in the area of consumer protection. Representative Tom Murry, who represents the District 41 in the House of Representatives, which I believe covers a bit of Cary, Morrisville, New Hill, and Apex. Is that right? Very good. So we're glad to have him with us today. Rounding out our panel, we have John Boswell, who is Senior Vice President and Chief Legal Officer for SAS, a little company you guys may have heard out in Cary. We have Matt Johnson is joining us today from Washington, D.C. to give us some federal perspective. Matt is currently Executive Vice President with McBee Strategic, a political and communications firm, and also formerly served as Chief Counsel to Senator Cornyn. So we're pleased to have him here today to talk with us about some federal issues. And then finally, last but not least, Mitch Mumma. Thank you so much for being here today. Mitch is general partner with Intersouth Partners, which is a venture capital firm that invests in technology and life sciences companies throughout the Southeast. So we have, I think, a good, diverse panel here today. And we're just going to go down the line. We'll start with Representative Murry and just ask each of you for 2 minutes of, who you are, what's your interest in patent reform or patent trolling, and what are you guys working on that we might find of interest.
Thank you for the introduction. Thank you for being here today. I'm glad to see such a wide array of interest. I think there's more people in this room interested in patent trolls than there were in the General Assembly when I presented this bill, since there was no debate on the bill on the House floor and it passed unanimously, which is exactly what you want out of your any legislation you're working on. That means you're either working on something that's so complex nobody understands what you're talking about, which is definitely the case on patent trolls, or everybody's in such agreement that you've obviously hit it out of hit a home run on this one. So my interest in patent trolls actually started, the first time I actually heard the word patent troll was a tweet sent out by the Attorney General's office. And so and that was after our Attorney General signed the letter about I guess it's been about a year, maybe more than a year ago, about the federal legislation. So that was my first introduction to the issue, and I started reading up and the link that the Attorney General's office provided. So I read up on that, and the next time I heard about the issue was from Congressman Holding, because he really dug in on this issue on Capitol Hill, and he mentioned it in a political gathering that was an example of the legislation that U.S. House of Representatives working on to help advance America and protect innovation in our country. And then the last time I heard about it was when Senator Stevens brought the idea to me on behalf of his client, SAS, and we started working on legislation prior to the short session this year, and got as many people around the table. Not everybody was happy to start, but we got them all happy by the time the legislation got to committee, and we had and especially the university system. I think I can't understate the importance of having the university system engaged on this particular issue. I know there were some major concerns the universities had on federal legislation, but we were able to address those here in the state of North Carolina, and having the universities neutral on this bill was exceedingly important. But from an innovation perspective, my perspective on innovation, I started working on helping startups with the crowdfunding bill that I worked on in the long session last year, and so that kind of got me into the soup of the ecosystem of innovation in our state, and I've started hearing from the community that we need vitamins and painkillers, it resonates with me as a pharmacist, and so I view crowdfunding as a vitamin and patent trolls as a painkiller. And so that's my interest, in to make sure that we have a warm place for innovation to happen in the state of North Carolina. You know you've got protection in our courts, and you know that you've got an opportunity to raise some money, raise some capital intrastate through crowdfunding. Hopefully we can get that legislation passed this session too. So that's my interest in this legislation, and I was proud to be able to work on it.
Great, thanks. Again, I'm Mitch Mumma with Intersouth Partners, which is the Southeast's largest and oldest venture capital group, and I've spent 25 years partnering with entrepreneurs to help them build great companies. And as you probably know, at the start of almost every venture-backed company is a set of intellectual property, usually in the form of patents, not always, but almost always in the form of patents. And those are usually at the spun out of the universities or RTI or some other place where intellectual property is created, or perhaps by the entrepreneurs themselves. And then we spend a lot of time before we ever write the first check trying to figure out, is there freedom to operate with this set of intellectual property, and how can it grow and create value over time? And so, both from my perspective and the National Venture Capital Association's perspective, this issue of the abuse of patents by the folks that we'll talk about stifles innovation, at least from my seat at the table. It lowers return on investment. It probably lowers the amounts that are actually invested. And you know, there's some legal extortion involved. We can talk about that later. That's my term for it. So anyway, it's kind of very near and dear to the heart of most venture capitalists who have had experience, as we have, on both sides of the issue. And as Representative Murray said, I think it's equally as important. It's awful for our companies to receive these letters and engage in the legal extortion that then occurs. But at the same time, they need to be able to protect their intellectual property in the court system. And so we have to have laws, both at the federal and the state level, that do no harm. I'll stop there.
Matt?
Thank you very much. Thanks to Brooks and NCTA and the Research Triangle Park. I'm honored to be here with a distinguished panel, including Mr. Attorney General, Representative Murray. I'm here on behalf of Tech America and CompTIA, and want to give you a little bit of perspective from the federal level. As has been said, there's legislation that has been, I think, stopped in its tracks in the Senate Judiciary Committee. My history with this issue dates back about 7 or 8 years. I worked for Senator John Cornyn of Texas for almost a decade as his chief counsel, and starting probably around 2005, worked on patent legislation for him. And that legislation was focused mainly on damages issues. It eventually morphed into what is the American Invents Act that was passed several years back. Again, focused on patent quality issues, not necessarily litigation. And so over the last few years, we've watched the evolution of this issue from patent quality to patent trolls and patent litigation reform. And so My role in all of this now is representing clients before the Senate, before the House of Representatives on patent reform litigation. And so hopefully get a chance to offer you some perspectives on what happened and what is to come.
I'm Roy Cooper. I've been Attorney General since 2001. Before that, I was the managing partner of my small law firm, concentrating mostly in civil litigation. Also served 14 years in the state legislature. You name an issue, I'll tell you how the North Carolina Attorney General's office is involved in it in one way or another. We do have an area called consumer protection, and most people think that involves just individuals, but it doesn't. We also help small businesses frequently, and we realize that consumers need jobs and that a strong economy is critically important to North Carolina. For example, in the small business area, the largest group of complainers about deceptive automobile advertising is automobile dealers. So you know that businesses are concerned about what other businesses are doing, and our office often plays a role in that. When I look at a number of the people out here with whom I've worked over the years, we know that North Carolina is a place for technology and innovation, and this Research Triangle Park has provided a real spark for our state, and innovation is critical. It's important for people who do research and who innovate to be able to protect that investment and to be able to get a patent and to be able to make money off of it. That's a positive thing. But what we've seen happen over the last few years is abuse of the patent system. You've had these companies, they're called patent trolls, they're called patent assertion entities, they're called non-practicing entities. Well, essentially they buy a patent, they don't innovate, they don't use it for anything other than to make the money off of it and to try to acquire licensing fees. And what has been happening out there is a number of these companies that use shell companies have come in and have blanketed businesses not only in North Carolina but across the country with letters saying, hey, we've got a patent on your Wi-Fi, or we've got a patent on your software, or whatever it is, and pay up, pay the licensing fee. Oftentimes they don't tell you specifically what it's about, what their assertion is, how much of it is involved with the work you do. They don't even do a whole lot of research on what's a fair price. They're just trying to collect money. And this is an abuse of the legal process, an abuse of the patent system. So what has happened is that first the federal government got interested in this. Even the president announced it, and some legislation was introduced and got through the House. But as typically what happens in Congress, glacial speed starts taking over and nothing happens at the federal level, as it hasn't happened yet. So a number of states have stepped forward, and I'll just step back a second. I'm sorry I'm running over just a little bit, but it is critically important that states maintain their ability to protect consumers and to assert their consumer protection laws. We often talk about federal preemption of state laws, and that's appropriate in certain areas, and certainly in the patent area, that ought to be exclusively in the federal domain. States don't need to be getting into messing with patent law. But with the legal system that's being used and with consumer protection being involved, states ought to be able to protect their businesses and protect the people who are being abused. And oftentimes states do, they're the laboratories, the laboratory of democracy. States come forward and do ideas quickly. And so you've seen a number of states step forward and attack this thing. Two of my colleagues in Vermont and Nebraska, and there may be some others who have used the unfair and deceptive trade practices law to sue these guys. We've got one under investigation now because we've gotten a few complaints from businesses in North Carolina. where we are getting ready to move soon. And now you've got state legislators across the country, like Representative Murray, who have come in and said, hey, we ought to have a private right of action for somebody to bust the chops of these companies that are doing this. And secondly, you ought to give the Attorney General some specific authority to go in and stop it. We'll talk about this legislation in a minute, but this legislation will help our office to hone in on this problem, and we look forward to talking with you about it.
John?
Hi, everybody. I'm John Boswell. I'm the Chief Legal Officer at SAS. SAS, for the last 10 years, has had a steady diet of being sued by patent trolls. That's actually really the only litigation that we have. It's dramatically expensive, time-consuming, distracting, and it's as a result of the confluence of several factors. One is, for the last 20 years, the Patent Office has been overwhelmed and has been issuing poor quality patents in the area of software and business methods. But nonetheless, a patent has a presumption of validity. You bring a patent in front of an unsophisticated jury in East Texas, and you have a pretty good chance of getting to trial and maybe losing. But even more problematic is it is extremely expensive to go through patent litigation. Patent trolls have no employees, they make nothing, they sell nothing, they market nothing. And so there's a real disparity in the burden of discovery. So a patent troll sues you, tries to make discovery as expensive as possible, operates under a shell company, and you get into a situation as the general counsel who has a budget. Do I fight this thing and cost myself millions of dollars, or do I settle? If you fight it, you lose. If you settle, you become an ATM machine, because the next one's coming, and the next one, and the next one, and the next one. It's a lose-lose proposition. That's why it's so important, and why I'm so appreciative of Attorney General Cooper and Representative Murray and other efforts to try to level the playing field, to give us, the companies that are being abused, an opportunity to bring a separate cause of action against those people who are misusing the legal process for extortion. And that's the whole idea. The whole idea is, right now, a patent troll can sue you. If they lose, they're operating under a shell company. If you get an award of costs or attorney's fees, you can't collect it. I'm telling you from personal experience. You can't collect it because there's no money there. But if we can change the paradigm and have those people who are participating in this abuse have some personal skin in the game, well, it might change their behavior. And here's the beauty. For every company that doesn't get sued, we just save them millions of dollars, or at least hundreds of thousands of dollars. But we'll never know who they were because they didn't get sued. So the whole idea behind the efforts that we've got here is we're trying to change the paradigm, trying to make North Carolina a less fertile ground for this sort of behavior. And it will inure to the benefit of all North Carolinians, all companies, all employers. We won't be able to sit here and tell you which one it was, but it will make a difference. And that's why I'm so pleased that our elected officials are taking action. Thanks.
Thank you, John, and thank you, Attorney General Cooper. I think the two of you framed the issue very well in terms of what the problem is for a North Carolina company who's facing a patent troll. I've been asked to let you know the Twitter hashtag is hashtag #TrollReformNC. If you would like to send out any tweets about this, that's hashtag #TrollReformNC. Representative Murray, I'd like to come to you and ask you if you wouldn't mind updating us on the bill that we've been talking about. Exactly what does it do or would it do for North Carolina businesses?
Thank you. Currently, the bill has passed the House. The Senate has passed the same exact language as part of a larger package, both of which passed unanimously, and both of which are awaiting action in the opposite chamber. So the House bill is waiting action in the Senate chamber. The Senate bill is waiting action in the House chamber. And sometime in the next 2 weeks, one of these bills will become law and go to the governor's desk. But basically what this does, it expands the definition of unfair and deceptive trade practices to include abusive patent assertions. And there's a host of factors. If you're looking at the bill, after the definition, the first page, almost the first 2 pages of the bill are basically framing why this legislation is needed, and that's always good. Should someone decide to challenge this legislation, which my understanding is the first state that passed this is Vermont, and their legislation is being challenged in federal court. So one of the things we do for the court, just in case they have a lazy clerk, we identify all the good reasons why this bill is needed in the first page and a half. So that will help them determine this law is necessary and not violative of the U.S. Constitution. Next page is definitions, where we define the interested party, affiliates, what the demand looks like. And then when you look at page 3, starting on lines 21, we start identifying the key factors on determining whether a demand letter is valid or not. If you send me a letter and you don't tell me what patent number you're talking about, that's a pretty good indication that it's just a fishing expedition. The name and the address of the patent owner, the factual allegations, explanation on why you have standing. These are just basic boxes. I think this helps people who want to do a valid patent assertion do it right. And so I think this is a two-way street. It's not just an indication of bad faith action, but it's also an indicate. You can use this as your checkbox to determine that it is a valid claim. Similarly, going on to page 4, there are a set of factors that the court can consider. Let's go back a little bit. These are findings of fact made by a court of law. And so at the end of the day, unfair and deceptive trade practices is a finding of fact. And these are the things that can help a court determine what is abusive patent and a bad faith assertion of a patent. And so starting on line 21 on page 4, you start talking about the things that a person would not be making a bad faith assertion. There's a list there as well. So I think this basically sets the margin of what's a good faith action, what's a bad faith action, and opens up the ability for companies small and large to have a cause of action in the state court to go after somebody who's making a bad faith claim. We also have bond requirements, enforcement remedies, and we also give some power to the Attorney General's office to engage in activity as well.
So, Representative Murray, my understanding would be that under this bill, if a patent troll sued a company like SAS and there was a finding of bad faith, then SAS could actually sue them under this bill. Is that correct? They would have a right of action under this bill.
That's correct. The shell entity would not be protected for this bad faith action. You would be able to pierce the corporate veil, go into personal assets of the perpetrator, and that's consistent with unfair and deceptive trade practices. And we're just expanding that to include bad faith assertions of patents. Right now, today, if you're a victim of unfair and deceptive trade practices, you can pierce the corporate veil and go after personal assets, get your attorney's fees, and plus treble damages. So if you have $1 million worth of damages as a result, you get to triple that and pay your attorney's bill as well, going through the corporate entity and attacking the individual's assets.
Thank you. And Attorney General Cooper, Representative Murray mentioned that there would be some additional powers for your office. What current tools does the AG's office have to work against patent trolls, and what potential new tools do you see coming out of legislation like this, either in North Carolina or things you've seen in other states, other AG offices?
Attorneys general across the country often bond together in what's called multi-state actions, or we either encourage federal agencies or the United States Congress to take action. The first thing we did on this issue was to encourage the Federal Trade Commission to investigate this and to use their investigative authority to move forward. They're now studying this issue and collecting data to determine what kind of action that it can take. We also have the very broad unfair and deceptive trade practices law, which is Chapter 75, which allows us to assess penalties, get treble damages, attorney fees. It's a very broad area of law, and we have to prove that something that one of these companies did was both unfair and deceptive, which is a pretty high bar. We see a lot of actions by individuals and some companies out there that easily meet that bar, and we're able to stop them from doing bad things. But with a patent troll, you aren't necessarily being deceptive when you send a letter, and I don't want to say that they aren't, because we would argue that they are, but it is more difficult to prove deception because they don't provide a whole lot of information when they assert their claim against the company. So this would establish, the new legislation would establish a bad faith standard wherein they would affirmatively have to do some things in their letter or assertion to you that they have a patent. And that would allow us to take action if they fail to perform the requirements of this legislation. So we think it broadens our authority and makes it more effective. We don't think it goes too far because, as Representative Murray said, this is information that a company that's asserting a patent ought to have and ought to know when they assert the patent. So we look forward to this broader authority when it occurs. That's happening in a number of states across the country. Not all of them yet, but a number of them have begun to pass these statutes, and a number of attorneys general offices have moved to take action. Nebraska even began an action against one of the law firms in Texas that was bringing these things. And we have done that in the cases where you have this debt counseling or debt settlement services. They hide behind an attorney's office, and we've taken a number of these attorney's offices to court. So you may see more of that when this law is passed as well.
Very good, thank you. Just a reminder, hashtag Troll Reform NC. I'm doing my PR duty for you there, Brooks. Given all of these actions at the state level, Matt, can you talk to us a little bit about what's happening at the federal level? Is there a risk of preemption with these sorts of state statutes, or maybe not now since legislation has stalled, but as things move forward, what do you think on that?
Sure. So to back up just a little bit, the bill that was being put together in the Senate Judiciary Committee included various provisions from heightened pleading to fee shifting, some discovery reforms, and there was a hope that several of these issues, including demand letters, including some joinder provisions, would all be pulled together into one comprehensive bill. That didn't happen. That effort is stalled. But there is a sort of satellite effort going on now in the House of Representatives. Lee Terry, who is on the Energy and Commerce Committee, has a bill that's quite similar in giving broadened authority to the FTC to go after bad faith actors on demand letters. That Terry bill contains, as Melanie alluded to, a pretty strong preemption provision. And one of the considerations going forward in federal legislation is going to be if you have several of these state laws concerning specific requirements on demand letters, what do we do? Do we set a floor for requirements or a ceiling for requirements to demand letters? Do we preempt state demand letters? I was talking to a staffer this afternoon who said really from his perspective, and this is someone who's been deep in the negotiations, from his perspective, there really oughtn't be federal preemption, that we ought to let the states work this out as well, because it is a consumer protection matter. That was one staffer's view of this. So keeping that in mind, that's going to be one issue going forward, is what do we do about preemption? But I think we've got some time to work that out. I don't see that Terry bill moving forward with any speed, certainly not this Congress.
Was it glacial speed, I believe, that Attorney General Cooper pointed out? So, Mitch, from a business perspective, do you see that a bill like this at the state level could have a positive impact on the businesses that you represent?
I do. This is, I think everybody's on mostly the same side of this issue. It will be better if frivolous actions could be curtailed like the way we're talking about here. I think what worries me is the other side of that, and that is it is a legitimate business model to monetize your patents through licensing. In fact, it's a pretty good one. And so we need to make sure that when we pass this legislation, we don't prevent our businesses. I mean, I can already hear what happens every time there's a demand letter, and unfortunately, one of my companies has been abused by their prospective customers who are in violation of their patents, and so we sued them to protect our intellectual property. And I can see a law like this being used very defensively because this is a matter of our resources versus theirs, and theirs are obviously significantly greater than ours. So I hope that, you know, the legal community will come around and organize this in such a way that it doesn't turn out to be negative. I'm going to make one more comment. If you take a cell phone, there are about 250,000 patents that have been issued around all of the pieces all the things that make this work, and a global supply chain of tens of thousands of parts. This is, and the technologies associated with the semiconductors and software that are in here are unbelievably complex. And so, for instance, to figure out what a reasonable amount for a license would be for some small component of this that a small company may have innovated, it might be really hard to figure out. I mean, it certainly would be hard to figure out, and it's not, and it's a very specialized area of both law and technology. So, it's not a slam dunk.
And that's going to your earlier point, a good point there, Mitch, in terms of kind of the risk. And I want to talk to John about that too, because SAS is both a potential target, but also I'm sure holds patents of their own that you want to be able to license and protect. You know, does legislating, you know, this sort of activity, you know, does this run the risk of harming a business like SAS or other technology businesses?
No. To expand upon that, the challenge both at the state level and the federal level is you know a patent troll when you see one, and you know a legitimate company that's trying to monetize and, you know, their patents. But that's exceedingly hard to write because everybody has, well, what about this? Well, what about that? Well, what about that? I mean, everybody's concerned about the edges. So you'll see in this bill, there's been a lot of exceptions. Companies that make more than 50% of their revenue, you know, through the sale of products and services, not including patents, that we call them operating companies. We've just taken them out of the target list of people that can be sued. Universities, we've taken out. Drug companies, you know, claims that could be made under certain sections of the U.S. Code, because those are not the entities that are the problem. Operating companies don't have the time, the energy, or the resources to go around harassing people. They might have a legitimate competitor that they want to litigate against, and that's legitimate. We have patents. We haven't asserted them, but we believe that they help us when we're in negotiations with companies like IBM and others who want to assert their patents against us because they see that we have patents we could assert against them. And that's legitimate, and that's the way business has operated for a very long time. It is only when this new paradigm came about in the last 20 years where you had bad patents, expensive litigation, and then jurisdictions like the Eastern District of Texas, where the judges are using patent litigation as an economic development vehicle and want cases brought there, and it puts you into, I mean, you're just in a lose situation. And that's why this legislation is so important. But I don't know of any technology company that is concerned about this type of legislation because it's clear who we're talking about and who we're not talking about. Now, Mitch, if you think I'm wrong about that, I'd love to hear you argue.
Oh, no, and actually I'm a supporter of the bill. I'm worried about it because it can be used as an offensive weapon. I think that it's not that it could be used as a defensive or offensive weapon by the bad guys is not a really good reason not to do it. It's just a reason to be careful.
Fair enough. Thank you both for that. And then let's play devil's advocate, and I'm just going to throw it back to John because I enjoy hearing you talk. Don't companies have a legitimate right to make money, even if they're not practicing? You know, let's just say you invest in and you buy a bunch of patents and you want to be able to license them even though you don't make anything. Don't they have the right? Isn't that the value of intellectual property?
Well, you would be right if it was the value of the intellectual property that was being discussed. If it was the value of the patent that prompted the license fee. But that's not the value proposition of patent trolls. The value proposition of patent trolls is the cost of litigation. It isn't that I have a patent that is worth X amount of dollars. And if patent trolls came to you and said, I have a 13-cent piece of this cell phone, pay me, $38, we would say, fine. I'm going to haul you through court and I'm going to make you spend, and we have a case where we spent over $8 million defending ourselves. We won the case. We defeated them, the patent was found invalid. We won on summary judgment. The Federal Circuit affirmed that ruling. Woohoo. We spent $8 million. We got an award of just cost for a couple $100,000. The LLC had, $380 in assets. What good did any of that do us? So it isn't the value of the patent that is causing this business model. It is the cost and the distraction of the litigation. And that's where the unfair and deceptive trade practice comes in. They're not asking for money because the patent's valuable. They're asking for money because they will drag you through the mud and the briars if you don't pay them. That's the difference.
Thank you, John. Representative Murray, we'll ask you one final question, and then I'm going to open it up to the audience, so be thinking of your burning questions. In several states, I believe this legislation's been considered in over 20 states now. It has stalled in a few states. It didn't pass it through all of them, but it passed through North Carolina very easily. To what do you attribute that success and how easily it's gone through both the House and Senate here?
John Boswell. Well, I think it's an indication of the ecosystem in our state that we know that innovation is what made North Carolina what separates our state from any other state in the country is innovation. This is a tool to show innovators that you have a warm place to do business, you have protection in our courts. We want you to be here and know that you can grow. You can grow. You can grow your business with new ideas and have protection in our courts. And I think that was a reflection of the entire discussion through the Judiciary Committee, through the House Commerce Committee. I think the entire discussion was about how we can make sure that this is for small companies, for large companies to innovate and have protection in our courts. And I think that's why you're seeing this legislation move with such rapidity in the General Assembly this session.
Very good. Thank you for your leadership on that issue. So let's take a moment and open it up before we do #TrollReformNC. So what questions do you have? You can tell we have quite a panel of experts who know this issue very well. So let's open it up to the floor. Yes.
We love Newegg. They are what it takes in order to fight patent trolls is an owner or a board of directors that has the funding, has the means to be able to do it, and is mad enough to make a maybe not rational business decision. And I say that because I'm not sure if it's rational or not. One of the things that we are trying to do at SAS is to make ourselves a very unappealing target to patent trolls. Because when I said earlier, if you settle, you become an ATM machine, patent trolls know who the easy targets are and who the ones that will fight, and they don't want to get involved with a company that's going to fight with them to the death. I don't remember the statistic, but about 90% of patent troll cases that go to judgment, they lose. So it isn't, as I was saying earlier, it isn't the value of the patent that's the issue. It's the willingness to make it so expensive that a company will settle. Well, as soon as a company won't settle, the last thing in the world a patent troll wants to do is be in death litigation with a company, and that's what Newegg's willing to do. That's what SAS is willing to do. That's what more and more companies are willing to do, because for a long time we tried the other method, which was, okay, let's just settle it and be done with it because it's too distracting and it's going to cost too much money. And then you just, demand letters hit your desk one right after another. So that's what their business model is, and I wish them all the best in it.
Yes, Matt.
So Newegg is a great story, and I think whether or not it's a rational business decision is to be determined. But we've talked a lot about innovation and innovators and technology companies being sued. One of the reasons this issue moved so quickly through the House, and my theory is it will be resuscitated next year in Congress, is because the victims of patent assertion entities, patent trolls, expanded far beyond in the last few years. Technology companies. The face of patent reform in Congress this year were grocers, banks, mom and pop coffee shops. I mean, you had folks. Whataburger came up and testified. A burger chain in Texas. That's what drove patent reform. The technology companies, sure, they have the most and deepest experience. But when mom and pop shops and retailers and other non-technology firms got sued for being end users, that really started driving this issue. And I think it's worth thinking about when we put together legislation.
Good, thank you, Matt. Great point. And I believe a lot of these mom and pops are being sued. The licensing fees that are being asked for are like $1,000. It's not that they're being asked for much, but I believe, is that what's happening in North Carolina, Attorney General Cooper?
We've gotten a few complaints from people. I think getting the word out has been positive that a number of these mom and pops and companies are ignoring the letters, which is the fact that this issue has been brought out there, and I think that's been a positive thing too. They have to be careful because they could have a complaint filed against them, and then they're in a different situation. But many of them have now been ignoring these letters.
Very good. Other burning questions from the floor? Yes.
It's better what we got now. And so I think that's where I would start is this definition of interested party took a lot of work. I mean, it was because we massaged that definition probably, I would say, more than any other definition. I would read interested party in conjunction with operating entity, because on one side of the coin you have interested party. That's getting to the corporate veil. The other side of that coin is the operating entity, which received protection under this legislation. And so what we give, we take away. And I think that's the mark of good legislation. And so as you can, I could read the definition of interested party broadly or narrowly. I could do the same thing with operating entity. And that's why we have findings of fact in court, to help determine how far a company's tentacles reach and who's the person pulling the strings, and to engage in this bad faith behavior. So when the court determines you're engaged in bad faith behavior, anybody that touches you, you're in trouble. And that's the message that I want to send with this legislation, to make sure that you just can't hide behind a curtain and have $380 in the bank and expect that the state of North Carolina is going to turn a blind eye.
I think it will help us, but keep in mind we work very hard to do that now, Because the main interest of the Attorney General's office is to stop the bad behavior. And under the Unfair and Deceptive Trade Practices Act, we find a lot of individuals who do now use shell companies. They hop from place to place, they hop from company to company, and it's usually a few individuals who are causing the mischief. So we work very hard under the current law and oftentimes bring suits against the individual under the Unfair and Deceptive Trade Practices Act in order to get to the source of the problem. And I think it was good for the legislation to tackle that issue, because not just for recovery of money or an action that would be brought, but to stop the behavior.
Can I make one point of why this is so important? Prior to this legislation, one of the defenses that a patent troll has is, and I don't know what it's particularly, it's got some name, but basically they're using the court system in its intended way, allegedly, to pursue a right, their patent right. And so how could that be an unfair or deceptive trade practice? How could they be prosecuted for that? Because they are just using the court systems in their intended ways, et cetera. And that was always, whenever we were talking about going after patent trolls for, filing lawsuits, and we'd say, this is extortion. And they're saying, no. Extortion's when you put a gun to somebody's head and say, I'd hate for your liquor store to blow up if you didn't pay me money. I'm like, it's the same thing. They're just using the cost of the court system to do that. And this really takes that argument out. It specifically addresses, the state of North Carolina, have found this to be an unfair and deceptive trade practice. So it really changes the paradigm completely when you're trying to bring an action against somebody for this behavior.
And Representative Murray, sorry, we didn't really talk about the bond issue. Is that something that you could explain that's in the bill?
The bond, we did have a fair amount of discussion at least in one committee about the bond. The bond relates to the value of the patent. That's how I would read the bond section. And second, it's up to $500,000. And so I don't think some people would look at this bond as chilling as well. But if I have a valid claim, I gladly put up a bond. If I have a valid patent claim, this is really a cost of doing business. I don't have any problem doing that. So the way I would read the bond specifically is it's up to $500,000. It's not a $500,000 bond, and it's based on the value of the patent. The bond is based on the value.
So then the person the patent troll presumably would have to actually put up a bond of a certain amount of money in order to be able to proceed with their action, correct?
That's how I read it, just in case they decide not to pay any court fees.
But that's only after the court has made a prima facie finding that this is bad faith. And basically, you're involved in bad faith. If you want to pursue this further, you need to put up a bond because there's going to be an award of attorney's fees coming, and we need to make sure that there's a way there to have that award paid.
Thank you. And there was a question? Yes.
Yeah, my question was related to the bond issue. It was really directed.
That's a good question. I don't know the answer to that, nor do I know how that number was arrived at. Maybe you can help us a little bit there. But I think the concept of being able to get legal fee, of the loser pays legal fees, and this is a methodology to do that, is a fantastic concept. I don't think we'll ever get there for maybe obvious reasons, but I think the concept is great. But maybe you could tell us about the number.
I don't know. I think it's what every other state had in there. I think that's. I think that's pretty much. I mean, that's pretty much how we got to that number.
And this goes back to another concern, which is this is really complex, and putting a value on a patent is really, really hard. I mean, in many of our companies, we have tens of millions of dollars invested. So to say it's worth $500,000, who knows? It might be worth many, many millions. We hope it's worth many, many millions of dollars.
Yes.
I don't know how the legal analysis comes out in court. I can speculate on how legislators at the federal level would consider that scenario, but I would defer to others who have studied preemption a little deeper than I have.
I think we've had good success in the courts regarding exclusively consumer protection issues, and I think that there's a clear delineation here between protecting a consumer and the acquisition of a patent and what you have to go through to do that. I think it was maybe Chambers with Cisco that said that Cisco is now spending more on patent acquisition and litigation than on innovation. And that should be disturbing to all of us. I think that, the states have no business in determining patent law or determining what is a valid patent or the rules and regs of how you obtain a patent. I do think it's pretty clear that Washington does need to do something in that arena aside from this patent troll issue. But I think you can parse out the consumer protection side, bad faith, unfair and deceptive trade practice in the area of trying to collect on a license or collect on a patent. And Congress sometimes goes in and specifically preempts, and if it does that, then they could wipe out these statutes. So that's why I think it's important for them to leave it alone, or either to specifically spell out that the states do have authority in this area to remove any potential ambiguity.
And just to clarify, the Attorney General of Vermont, as many of you may have heard, did sue a patent troll on behalf of their state residents. And of course, the patent troll immediately tried to remove to federal court for that very reason, stating preemption that patent issues are the purview of federal courts. And the federal court rejected that argument and said that the state attorney general did have authority to bring under their existing consumer protection statutes that action on behalf of the residents, solely based on sticking with the tactics of the litigation, not touching the issue of whether or not the patent itself had any validity or the validity of the claims. Other questions? I think I saw a question over here. Yes.
End of the street in Washington. After, how do those challenges ultimately impact as is, but what's that dialogue or discussion between?
Here's what I think is actually a little bit the other way. I believe that the Supreme Court has been very lax in dealing with this problem. And I believe the pressure that has been put on by states, by Congress, and just by the business community, that something has to be done about this. And then I think when Congress seemed like they were getting serious about changing the rules around discovery, changing the rules around loser pays, and doing some other things that I believe the court didn't want them to do. And I think the Supreme Court took these cases and decided these cases because of the pressure that was being put on across all sectors of society, including states, businesses, articles in the Wall Street Journal and studies and everything else demonstrating how much of a problem was. I think that encouraged the Supreme Court to take these cases, not necessarily to decide them any particular way, but to address the issue, which they hadn't addressed much in the last few years. I don't think, but the Supreme Court's decisions about the standard for awarding attorney's fees and fee shifting and stuff like that, that all that all operates in the four corners of patent litigation, which this does not operate in the four corners. This deals with what patent trolls are doing prior to any litigation that they're involved with. So I don't know that it has any impact particularly with the states, but I can't speak to what's being discussed in the chambers or in, Attorney General's office, but that's just my opinion as to what's been happening there.
Speaking to federal legislation and the fee shifting issue, I don't think that what the court did with the existing statute is going to deter Congress from moving forward on that particular provision. I think you will see that revived and perhaps even stronger in a Senate version next year. You have obviously the president endorsing some version of fee shifting, which is important. Senators Cornyn and Schumer, obviously two powerful big state senators who are at the forefront of this issue, endorsing strong fee shifting, and obviously the House passing 300 plus votes. So I think you'll probably see that as part of a bill moving forward, despite the court weighing in.
Thank you, Matt. Yes, question.
The first in time in history, the Attorney General has deferred. Federal law, the venue statutes and the jurisdictional statutes are such that you can be sued in any state, and the idea is that you should only be sued where venue is proper. And a lot of these patent trolls are incorporated in the Eastern District of Texas with the idea that they can therefore sue companies there to try to manufacture venue. The America Invents Act had a provision which required patent trolls and anyone else to sue companies individually rather than collectively, with the idea that it would go towards defeating venue in Eastern District of Texas. But the judges in the Eastern District of Texas will not transfer cases, or very seldom will they transfer cases out of the Eastern District of Texas. So we are sued in the Eastern District of Texas. We have no connection with the Eastern District of Texas, but the judges won't remove the cases. And so far, the Federal Circuit and the Supreme Court haven't been particularly active at requiring them to do so. So even though we think it's inappropriate, we are hauled into Marshall and Tyler, Texas, and sued there, and we have to defend ourselves there. So the only way that this legislation helps with that is it gives us a cause of action in North Carolina against those patent trolls who are doing that if they are doing it in bad faith.
We have, in all areas of consumer protection, have asserted strongly that North Carolina laws apply to businesses who are doing business in North Carolina. So if you would send a letter, even though you're based in Texas, if you would send a letter to some North Carolina company asserting a patent claim, then we would say you come under our jurisdiction, and if they have not met the standards and they've done it in bad faith, then we could take action against that company. But I agree with John that I'm not sure that we could have a large effect on the original case that's brought there. But, you know, the idea is to discourage it.
Other questions? Yes, Brooks.
brought up by some companies that listen in the routine. Up to an eventual demand letter. Maybe what's there.
Well, you raise a good point, and that is that, as I was saying earlier, you know a patent troll when you see one, you know bad faith when you see it, but in trying to write legislation to curb it, you might inadvertently capture what you don't intend to capture, which is the sort of communications that two businesses might have. Look, I got 2,000 patents in this area. You've only got 200. Let's do a cross license, and you pay me $1 million. Well, that's not patent troll. That's the way that companies are monetizing their patents. And so we couldn't figure out, and Representative Murray couldn't figure out how to write it any better than what we did is we started exempting categories of companies. I don't think that's a good idea, but we couldn't come up with a better idea. The idea being that even if you're an operating entity or a pharmaceutical company or a university, if you're being abusive and you're operating in bad faith, you shouldn't do it. But the problem is we couldn't figure out, and because they don't generally do that, it's not the problem we're trying to solve. The least offensive way to deal with it was to exempt categories of companies and businesses and universities, because they're not the problem. If they become the problem, I'm sure Representative Murray and Attorney General Cooper will deal with it. But until they start becoming the problem, we felt like it was probably best not to not capture them in the tentacles of this law.
And I'd say if you're not asking anybody for any money and you're just talking about patents, then I don't see how that could ever be turned into a demand letter. If you're just
You're always asking for money if you're talking about patents.
So if you're just having a friendly business discussion via letter, and you're not really talking about fees or licenses or just pay me with this much money in this amount of time, because that's at the end of the day, that's really what the deal's about for patent trolls is pay me this amount of money, this amount of time. If you're just talking about, I think we have some cross pollination on patents and trying to work out a deal. That's a different conversation than pay me this amount of money in this amount of time.
You've got that open factor on both sides of the case. I mean, it's very difficult to specifically define everything that you can think of. You should play as many what-ifs as you possibly can when you're writing legislation and putting it into practice. But for example, with the unfair and deceptive trade practices law, it's difficult to imagine all of the circumstances where it could be used. And of course, now we've got a good, strong body of case law that's been built up over time, which helps us define it. But most of the time, it's only used to go after the bad actors. And I think it's a positive thing to leave this open because you can't specifically define everything on both sides of this issue.
Yes.
We are an IT company here in Raleigh. This is a couple of red flags when you go unanimously. Small company here, $500,000 bond on a company like lawyers' fees, dollars, and I'd have to do that in multiple places. Not a non-practicing entity, but I am a small company. A lot of small companies like myself that are funded and RTI. It's great, with all due respect to SAS, I understand the position you're in,
that it is, and I'm agreeing 100%. My problems by yours, and you have 10, 20x easily of mine. On the other side of that equation is how this will be used offensively against me, stifle me. I wonder if there's any cost modeling that you did. How many small businesses, successful small businesses, exactly what the ramifications would be. Small company versus a large company.
The working group included Retail Merchants Association, Technology Association, and various other representatives from technology companies as well. But the Bankers Association was involved in this, and these are the bankers are the folks that fund you, and so they're interested in both as small banks getting patent assertions for their ATMs or their check scanning technology, but also as an entity that funds startups and small businesses to make sure that they aren't being unfairly targeted as well. Unanimous bills might make you nervous, but at the same time, I think this is an indication that we are putting things in place to put a protective hedge around innovation. And if you can meet these targets, the $500,000 bond only happens to bad faith actors. That's I think we've mentioned that already. That's an after the fact. You have been declared bad faith. Now you post a bond. That's not you. And so I think this is what this legislation seeks to do is to separate the sheep from the goats. If you're engaged in this proper activity and you're executing demand letters in this proper way, then you're safe. If you're not, you're in trouble when you're in North Carolina.
I think in just about every instance, this protects small companies even more than the SaaS and some of the others, because the small companies are the ones that have a difficult time with the resources to defend these cases. And from my perspective as Attorney General, SaaS can defend itself. They've got the help that they need to do that. But when we have a number of these small companies that complain to us, we'd like to have better tools to assert on their behalf to protect them. So I think, unless your company is a patent troll under the definition, you will be in better off after this passes, because you're much more likely to get one of these letters than you are to actually assert a patent under this situation.
Smaller companies. Small wedge. Used as an offensive weapon. Greater good for the majority, you've got that. And I'm not saying you've got that, so based upon the wedge here that this could be turned around very specifically in a lot of money. I don't know how you can limit that.
As Representative Murray said, there was a large group of organizations that both represented large and small companies that were involved in this coalition, including the Chamber of Commerce. And it was certainly never our intention to leave a legitimate operating company or a company that was trying to legitimately enforce its patent rights out in the cold to protect others. Because the bonding requirement only applies once there's been a finding of a reasonable likelihood of a bad faith assertion. So if I assume that you wouldn't do that, and so the bond would never come into play. And if you legitimately find an entity that is violating your patent and you've done the research and you've done all the things that you should do, then this bill should never apply. And And then to your other point is will companies like SAS and others who get sued maybe use this as a way to enhance the defense? Sure.
Thank you for your question. Other questions? Yes, Ron.
Ron Powers, Securities Lines. I'm curious how you see the offer patents and abstract use. How is that going to affect it? I mean, patent troll. Portion of the software patent isn't really patentable.
Well, let's hope they come down with that decision. A lot of the business model of patent trolls is because of poorly drafted software and business method patents. It would be great if the Supreme Court tightened up those rules. I don't believe that they're going to say there's no more software patents, because so much of the innovation in the last 20 years has been around software and about computer-aided things. It would be great if they came down with a more, a tighter, but all that's going to do is give defendants, once they get into litigation, an additional summary judgment motion, which doesn't really change the paradigm of I'm going to sue you and make it so expensive that you'd rather settle with me. That will help on the back end of winning the case, but it doesn't really help on the front end of not getting sued, because remember, patent trolls really don't want to litigate with you. They just want to threaten you so you'll write them a check. And this would help some, but it's not going to help like this will help.
I want to wrap up our session by first thanking all of our panelists. We're going to wrap up with a final question, and then I'm going to turn it over to Brooks, who I know has some closing comments. And the question to all of you is, how should businesses or NCTA, or businesses who are part of NCTA, how can we get involved in this issue? Or if we have concerns, who do we express those to moving forward?
Well, I think I would focus on Congress. I think we're checking this box this session in the General Assembly here in North Carolina. I would focus your comments and efforts on Congress to make sure that, especially for multi-state companies that have presences in multiple state, different areas and different congressional districts and different U.S. senators besides just North Carolina, I would focus my efforts on Congress specifically. But another thing I wanted to say in closing is, MIT I think I heard John speaking about this or out in the hallway, but MIT just recently did a study on the cost of patent trolls and how much less venture capital is investing because of abusive patent litigation. So I think the ultimate bottom line on this issue is it is costing innovators money, and there is a chilling effect on investment. Because if you are in a highly litigated intellectual property area, venture capital looks with you with one eye closed. And if we can check this box as a nation or as state by state, then it will put more venture capital money in your pockets, and that will help you as a small business.
If you believe you have received correspondence from a patent troll, or if you've gotten a letter, we want to know about it. Let us get that information, particularly the trade groups. Let your businesses hear about it, because we are hearing from restaurants and other small businesses having received these letters. For example, like their Wi-Fi. They just bought their Wi-Fi from someone, and all of a sudden they get a letter saying they owe money on a license for a patent. We'd like to have that information.
Thank you.
I would encourage everyone to follow the issue closely in Congress through NCTA, through TechVoice and CompTIA and Tech America. I think, to bring everything together, I think it's important for your North Carolina U.S. senators to know your stories, if you have them, and for this legislation as it moves forward, the reasons behind it, the voices behind it, to be broadcast to your senators and representatives as well, because that in and of itself is helping. The state action is helping drive federal action, and I think that's important to keep in mind.
Thank you, Matt. John? No. Mitch? All right. Let's turn it back over to Brooks, who, again, I want to thank for hosting us today. We appreciate all he's done for us.
Thank you, Melanie, for moderating, and certainly to the panel. I think one of the nice things about coming to a session like this and you hear calm, rational, intellectually healthy discussion with elected officials involved, it sort of goes against the stereotype you see on evening television and all the screaming that happens. So we're happy to bring you adult conversation. And really want to thank Attorney General Cooper and Representative Murray for taking time out of their day to be part of this, and some of the leadership that they have shown, and our other panelists who bring their own perspectives to it and deal with it directly or indirectly in their own ways. I also want to thank RTP for hosting us, and want to be sure and thank Adapt IT Ventures and Austin and Bird for helping sponsor today. We'll have one more session under this TechVoice banner this year, a little more fun and sort of election season oriented, and that is on October the 9th. You want to mark your calendar. We will be convening actually at Red Hat in their downtown, the Gleaming Tower as we call it, for a bit of content and some social networking. So 4 o'clock to 6 o'clock roughly will be a brief presentation and discussion that will feature the polling director at Public Policy Polling. Many of you know that's a North Carolina headquartered Democratic-leaning firm. And then Public Opinion Strategies, a Virginia-based national Republican-leaning firm, both of which are award-winning firms for the quality of their work. And leadership from those two firms will be down to give us a bit of a sense of what they see happening both locally and across the country a few weeks later on Election Day, mood of the public and all of that. Then we'll adjourn for some refreshments, a little stronger than the Coke you're drinking, right thereafter, because you're at Red Hat, where they know how to have fun. That's right. So I really thank everyone for taking your time today to be here with us. Enjoy mingling a bit here before we leave the building, and we hope to see you on the 9th, if not sooner. Thanks very much, everyone.